I'd like to welcome everyone to the Nashville Bar Association Town Hall meeting with District Judge Waverly Crenshaw in the District of Tennessee, who has been kind enough to share some of his time with us today to talk about changing court procedures in light of the COVID-19 pandemic. Welcome, Judge Crenshaw. Thank you for being with us.
Thank you for your invitation.
I'd like to start with a general question, and I know that your court sees a lot of different matters in it, but if I could ask a broad question about how court procedures have changed, and then we can kind of narrow it down from there.
Sure. For practitioners, the biggest order that you want to pay attention to would be our Administrative Order 209. The middle of March, we suspended all civil and criminal jury trials. That continued throughout April and will continue to the end of May. And we'll make some decision before then on what to do in June. But for right now, there are no criminal jury trials, there are no civil jury trials, and the grand jury has been suspended from any further proceedings for the time being. That has not, though, changed the expectation of our district judges or magistrate judges in terms of existing case deadlines. In fact, the administrative order specifically points out that among the district judges, we're unanimous that we do expect the parties and their counsel to meet all existing deadlines and not assume that the pandemic has caused a deadline established in a case to be changed or excused. We are available, obviously, to hear any motions that need to be made to adjust it, and I'm doing that and others through telephone conference calls, some video conference calls, some in-person proceedings, but we are holding people to the deadlines established by the presiding judge in your particular case.
In making the decision to continue all jury trials now through the end of May, I noted that the court actually conducted some polling of jurors who were summoned for jury duty in the month of May. Can you give us some insight into how you went about that and what results you got?
My jury administrator contacted all of the persons who'd been summoned for jury service in the month of May, and recognizing that some of the restrictions were beginning to be adjusted, as well as the impact of the pandemic subsiding to some extent, we wanted to have some kind of objective basis to say or not say whether or not we should have civil and criminal jury trials. So we simply asked them a series of questions getting to the issue of whether they were willing and available to serve both on the grand jury, the two grand juries that have been summoned, as well as those summoned for service in May. And by a pretty substantial margin, the majority of the people that we polled were either not willing or not available to serve. So that helped us guide the decision on what to do and give us some measure going forward to make sure that we are sensitive, that citizens have to stop what they're doing, come and serve. And during these times, we recognize they may have many other demands on their personal lives.
For the matters that are being held telephonically or by video conference, is there one particular method being used by all district judges and magistrate judges, or is each judge kind of coming up with their own procedure?
Oh no, we have one uniform procedure. As we expand our technology, and because of some limitations on what technology and the bandwidth that we have available here at the courthouse, each one of the district judges has an assigned date for proceedings. Mine is Wednesday. So we try to schedule all of our video conferencing on your assigned date. Friday is left open if you need to do any catch up. But on telephone conference calls, everyone is free to conduct those whenever and for as many as you want. So the only limitation the court currently has is on video conference calls, although later today, perhaps, we're going to hire a new IT manager. And one of the things that will be on his or hers top list will be expanding our capability so we can do multiple video conference calls in the future.
Is the court using WebEx or Zoom or some other software to conduct those conferences?
Yeah, we've got a specifically authorized software. We're encouraged not to use Zoom because Zoom is not secure. So we've got a process software that's been approved by administrative office, and we're using that right now.
And is that something that lawyers need to download onto their computer, and do they access that through the court's website or somewhere else?
Yeah, you're stretching my technology and information here. As best as I understand, you get an email from the courtroom deputy, and that will contain a link. That link will then bring you into the video conference call and with all the other parties that are available. So that's the extent of my knowledge. In criminal cases, if the defendant needs to talk to his attorney during the proceeding, it allows for us to create a separate conference room where they can go and talk, court will be adjourned while they confer, and then they come back to the link with the proceeding, and we proceed on.
What sorts of matters are being heard in person in the courthouse under these new orders?
Yeah, that's pretty much left to the presiding judge for that case. I know that one of our district judges done some pleas by, a few pleas by in-person. I'm going to have an in-person status conference tomorrow because it involves really 16 lawyers, and it'd just be unwieldy to try to do that by telephone conference. However, in light of the health concerns, I'm limiting all the parties involved, it's 9, to 1 lawyer each. And we'll keep those who are actually in the courtroom under 10. Everybody will have assigned seating that will provide more than 6 feet distance. And other safety measures will be provided, such as masks, sanitizer, gloves, if they wish. I don't anticipate the status conference is going to take long. So because it's a scheduling matter, it's just easier to do that in person. So we'll see how that'll be my first, I think, in-person matter since March.
Anticipating that at some point we go back to having more in-person proceedings or everything being held in person again, what is the court looking at in terms of social distancing, masks, gloves? How are you going to approach that when we are all back together again?
Well, it's going to be left to each one of the presiding judge. Each district judge obviously can do in his or her courtroom as they prefer. We will make available safety measures. So I envision there'll be hand sanitizer, masks, gloves available. Most of our courtrooms are large enough that you can have more than adequate space for social distancing. And we're exploring maybe some testing to occur before you enter the facility, the courthouse. Since we share this court facility with other government agencies, as you might expect, that requires us to meet with them, discuss their needs, our needs. But we are exploring probably some limited testing before you can enter the courthouse. And if you meet certain criteria, you may be excused from whatever proceeding you come from.
I want to take a brief pause to remind everyone on the call that if you have a question for Judge Crenshaw, if you'll use the chat function at the bottom of your screen to submit your question, and I'll be sure to ask it of Judge Crenshaw. Judge Crenshaw, moving back for one moment to the matter of jury trials, and then bringing in bench trials to that equation as well, what are you seeing in terms of a backlog, and what insight can you give us on how trials will eventually be rescheduled?
Well, on the criminal docket, obviously because of speedy trial concerns, those trials set in the last 2 weeks of March, April, and May. The presiding judge, district judge, will be resetting those probably immediately, I believe is what most of my colleagues are doing. So as soon as the administrative order went down, they take steps to reset the case for trial, and that usually involves a follow-up status conference, and we get a firm trial date for that matter to proceed. Now, for bench trials, we're all available to engage in those immediately, and that's really never stopped. So bench trials and any other hearings, especially evidentiary hearings, are available for in-person, and those are accepted out. And each district judge has discretion to hold matters in the normal course through an in-person hearing, and we've had a few of those. But obviously, we're very sensitive to the health concerns. Now that we've got a little bit more understanding and of the situation, we are looking at June, and if certain benchmarks are met in the district in terms of the number of positive confirmed tests cases, then I do envision we will want to at least explore doing a civil jury trial. As you all know, in federal court, you can do a civil jury trial if as few as 6 jurors. That leaves plenty of space in the jury box for them to spread out. We probably have large enough jury assembly room that they can maintain social distancing. We can also do other things to make sure that the jury is safe. Typically in the civil cases, you've got one party on each side, so the number of lawyers and parties can be controlled. So if certain benchmarks are made, a civil jury trial would be our first return to jury trials here in the Middle District. But the certainty of that is not clear right now. We'll have to see how May goes.
You mentioned the right to a speedy trial for criminal defendants, and I noted that in the court's orders, litigants, including the government and criminal defendants, can actually move the court to reconsider putting off their trial. Have you received any inquiries or any motions for that?
Not to my knowledge. I don't think we have. We've not had any jury trials, at least through since the third week in March to the present. And again, based on the polling, I've shared in the order, I am not sure that I can summon to the courthouse jurors that reflect our district and make sure it's a fair composition. So we've not had any jury trials. That hasn't been an issue to date.
We have a question from an audience member regarding a trial set in June. The court's current order only goes through the end of May. Can you give us any insight into when we'll know whether June trials will go? And I recognize I'm asking you something that is probably very uncertain right now.
Well, obviously, I don't know for certain. The hope of all the district judges is that we could at least have civil jury trials in June. Those persons who've been summoned for jury duty in June have received their summons. Some are reporting back to us without any polling about their specific concerns, but we'll make a decision about that down the road. But our first step back into jury trials, I hope, will be June. I hope we can do a civil trial, because we do recognize jury trials are going to be different in the future as we implement certain safety measures, and a civil jury trial would give us an ideal time to put that in place. And that's the goal of the district judges. So if you've got a civil jury trial in June, we would like to see that occur. We would like to use you for a guinea pig to make that occur. And I think we'll know more in May. Obviously, if safety issues change and things become more problematic, we'll reassess if we can do that.
With regard to existing deadlines, you mentioned, of course, the order that the court has put down and that the judges are all expecting litigants to abide by current deadlines. For new filings, are initial case management conferences being held, and how is scheduling being handled in those cases?
Absolutely no change for initial case management conferences. Those are being set when the case is filed as usual. They're proceeding. I think most of them since the middle of March have been by telephone or video. I know Judge Trauger is continuing to do her max by telephone, and the pandemic has had no impact on new filings or getting cases started, and the parties engaging in discussion about where the case needs to go and how.
I know the pandemic has raised a lot of new financial issues for people and for businesses. Has the court seen an increase in any particular type of cases since this all started?
Kent, I don't know that level of detail. I do get a report that the number of filings in April was normal, on average, maybe 5 below what it was in April of 2019. So the filings have not changed. So in terms of the types of cases, I don't have that information for April to see if it's any different from where it was in April of 2019.
On the state level, we've seen several efforts to release inmates and prisoners who do not pose a risk outside of the prison walls because of COVID-19 concerns. Are there similar efforts in our federal prisons?
Yes, the Bureau of Prison and the Attorney General have been implementing some internal guidelines or standards to release those persons to home confinement or early release administratively that do not involve court action. Separately from that, many are seeking compassionate release under the First Step Act. I did check on that. I monitor those, and since the pandemic, we've had about 20 such requests district-wide, and 2 have been granted.
Let me switch back to civil cases for a moment. And with regard to depositions in civil cases, is the court providing guidance to lawyers and litigants on conducting those remotely?
Certainly, I'm encouraging, I think we're all encouraging video depositions. The world has changed, and to keep cases moving, we need to set some of these by video deposition. Some pushback by members of the bar. I certainly appreciate and recognize nothing is like an in-person deposition for a lawyer to ask questions, but we are encouraging, not necessarily requiring video depositions, but in order to keep the deadlines in the case on target or adjust them a little bit, I'm really suggesting that you need to do it by video and persons are responding. I will compliment one of the most respected members of the Nashville Bar, Hal Harden, and certainly he has embraced video depositions, and we're all pleased that he's doing so. If such a member of the bar can do so, then others can follow Hal's lead and do more video depositions to keep cases moving and parties evaluating where they are.
Another trailblazer in Nashville has been Chancellor Ellen Lyle, who held a bench trial by Zoom or by video last week and actually live streamed it on YouTube so that it was still an open proceeding. Has the Middle District considered doing anything like this?
No, we're not to that extent now. Again, we can't use Zoom because it's not secure on the federal standards. But we have issued an order. I've issued an order that makes certain that the public is informed, gets due notice of all court proceedings, civil and criminal, by video or by telephone. And there is a provision that any member of the public can join in to the video or by telephone to any public proceedings. So if we were in the courtroom, members of the public can observe by phone or by video.
I note that naturalization ceremonies have not been occurring in person since this pandemic hit. Are those ceremonies happening in another way?
No. Under the statute, they can be new citizens can be sworn in by a federal judge, or they can take the oath individually before the Immigration Service. So I believe that's the way they're proceeding. That's the way they proceeded in March, April, and May. So they're getting the oath, becoming citizens, but they're not getting the opportunity or really the excitement that they all have. Those naturalization ceremonies are very inspiring in the courtroom before a federal judge. Not right now.
In planning around this pandemic, who have you and other members of the court been communicating with outside of the Middle District? I noticed in some of the orders, there's reference to communications with the Judicial Conference. And I'm just curious what different entities you're coordinating with.
We get almost daily, sometimes hourly, suggestions from the administrative office about how other courts are implementing procedures to accomplish various court hearings. So that's provided to us, but the overarching sort of philosophy is that each district is different, and districts are given wide discretion about how to ramp up proceedings going forward, or how to maintain things for a little bit longer if your district requires that. That was one of the things that was behind polling the jurors, because it gave us a real sense of what citizens are having to endure during this time, and whether or not it made sense to ask them to come and serve for jury duty. There's as many ways to do things as there are districts, 94 districts in the United States, and we monitor those. Some of them work for the Middle District, others we don't think would be feasible, so we sort of pick and choose what's best. We do have a Wednesday safety meeting. So I convene a safety meeting every Wednesday at noon that's made up of all the district judges, magistrate judges, the U.S. attorney, the federal public defender, the marshal, the chief of pretrial and probation, my current chief IT manager, and the clerk's office. So we will look at issues during the safety meeting in terms of what's on calendars, what criminal defendants, inmates need to be brought to the courthouse, and how we monitor that on a weekly basis. And that's worked quite well because it's a good flow of information and communication. We are able to determine if there are any positive confirmations within the courthouse, within our facility. And to date, we've only had 3 such positive tests. And it also gives us information that we can use to plan ahead. And that's been very, I think we've all appreciated that, because it gives us a sense of what's really going on without going through a lot of change.
We have a couple of follow-up questions from members of our audience. Going back to the court having hearings accessible to members of the public and the bar, the question is, can you give more information about that ability, and also how would a member of the public or the bar know how to call in?
Right. There's a public notice on our internet site that advises the public and lawyers, if you want to participate in observe a video or telephone conference, how to go about doing that. As I recall, there's a person in the clerk's office who will receive your email. You identify what case you're interested in. And then I think we provide you a link so that you can observe that proceeding.
And besides that notice being posted on the website for the Middle District, do you know if there's been any communication to the public at large about that access to the hearings?
Well, I know that the public notice was also sent to all of the media that cover the Middle District. So I would assume, our hope is that's one way to get it out to the public. We've got our internet, we've got the media. For lawyers, we can send a blast through our case management system, but we post it publicly as we would any other matter.
We have another question about jury trials, which I know is on everyone's mind right now. For cases set for this summer, are they likely to get kicked in favor of backup criminal trials?
Well, you mentioned that earlier. We're all very sensitive to the backlog of criminal cases that's being created. You take into consideration that typically, I'll just use myself, every Tuesday, I will set for trial anywhere between 8 and 10 cases. And when we get to Tuesday, typically they have all resolved. So now that, and the resolution we think occurs because you have the certainty of a trial date. So in the criminal case, that encourages a defendant to make a decision or we go to trial. So that's not occurring as much as we had hoped, but in our communication with the U.S. Attorney and the Federal Public Defender, I'm encouraged that lawyers on the criminal side are going to take more advantage of video and telephone conferences so we can have more pleas and decrease the backlog that's increasing every day. We'll see how that works, but yeah, at some point, it's possible that the number of criminal cases and the necessity of the speedy trial is going to bump some civil cases, but we'll just wait till we get to those trial dates or right before those trial dates to see if that actually happens. The reality is that many cases, as you all know, settle, and we know that way before at least I know it, way before the final pretrial conference, and I can adjust my docket accordingly.
And just another follow-up question on the public access to hearings is, are metrics being kept up on how many people are accessing those hearings, and who would be the person who we could contact if we wanted those statistics?
I don't know. That's a good question. Let me look into that. I did not request or I didn't order that we keep metrics on that. We've sort of been busy with trying to deal with other aspects of it, but if you want to follow up, I'll see if the clerk's office may be doing that anyway.
I want to remind everyone on the conference, if you have a question for Judge Crenshaw, if you'll submit it through the chat function and I'll be sure to ask it to him. Judge Crenshaw, in terms of the criminal cases that are heard in federal court, what has been the most challenging thing in adjusting to the pandemic?
I think right now is logistics. Many of the federal criminal defendants we do not have a detention facility here in Nashville. So many of them are being housed or have residence in facilities in Kentucky or sometimes as far as 2 or 3 hours from Nashville. So one of the biggest challenges has been coordinating access to defendants so that we can have proceedings, and trying to keep in mind that when we bring an inmate to the courthouse, we're potentially exposing the marshal service, our court staff, those other court staff members that are on the same floor. So we've been during our safety meetings, I always get a report on if any criminal defendant who's in custody in the Middle District has in fact tested positive. Because if they have, we take precautions to make sure that they are not brought to the courthouse, or if we have to have a required proceeding, then we do so in a way that doesn't expose them we expose them to as few people as possible to get that proceeding. For example, some of our criminal defendants are housed in the Davidson County Detention Center, and when one of them tested positive for the virus, through the coordination with the sheriff's office, we were able to conduct the required hearing because the person had just been arrested and we were required to do an arraignment within a reasonable time, and we got that accomplished. So that's been one of the biggest challenges, is making sure we know the circumstances. We don't unnecessarily expose someone or create a risk when we can find another way to avoid it.
Now, I'll ask the same question for civil matters that are pending in the Middle District. Have there been any different challenges, or what is the greatest challenge for those cases?
You know, most of those have not been in person. I think there's only been a few. And as far as oral argument or argument on request for injunction, all of that's been occurring by telephone. So that's been working without any problems. As you know, in federal court, we typically don't have oral argument on motions, so a lot of things are decided on the papers. So it really hasn't had any impact on the civil motion practice. We've not had any final pretrial conferences, so we've not crossed that bridge in terms of doing it by video or not.
Is there anything that lawyers can be doing to help the court move matters more efficiently that they aren't already doing, or any tips that you have for our viewers?
You know, I think staying in contact with the court and letting us know by motion, of course, if there's something about the pandemic that has impacted your case specifically. For example, we're very sensitive to lawyers who may be in a high risk category. And if I need to adjust the discovery process to address that, then let us know that sooner than later. Just don't assume that the pandemic creates some automatic extension of time or automatic change in the deadline. That would be a grave mistake. If you really have a way that the pandemic has impacted your case in a very real and substantive way, not just generalized concerns, then I would suggest you let the district judge or the magistrate judge know, because we're all available by telephone to address that. And for the most part, I think lawyers who are familiar with the federal practice have been doing that, and we're able to talk, address the issue, and keep the case on track.
Do you anticipate that the pandemic is going to affect the timeline for opening the new federal courthouse?
Well, as of Friday, the answer is no. We got a report on Friday that they remain on schedule for the summer of 2021. Judge Trauger has done an incredible job managing the building of the new courthouse, which makes, we're just so lucky to have her with the eye on that construction. And very happy to know that right now, the pandemic has not impacted the move into the new courthouse, but we've got a long ways to go.
Are there any silver linings that you've found in this situation, or anything that you're particularly grateful for during this time?
I think one lesson that we are embracing is the more creative use of technology. As I mentioned, we're going to hire later this week a new IT manager. In the interviews I've had with the finalists, I've emphasized the need to start thinking about how we can use technology in the future. I think some of the things that we're doing will continue. For example, video conferencing, telephone conferencing. I think even after we start doing more in person, that's going to be a tool that we use here in the district court for a lot of reasons. And we're comfortable with it now. As those who've practiced here know before, we have not typically done, or we only recently had even authorization to use video conferencing. And now that we have it, we're going to probably use it. I'm told there may be even consideration of amending federal rules of civil and criminal procedure so it's more available. So the whole use of technology is going to be something that we use going forward, and probably change in a very real way the practice in federal court that we've not seen before.
And I think you touched on this before, but one question I've gotten in several of the different town halls is, even once in-person proceedings come back, at least to some semblance of what we had before the pandemic started, will lawyers and litigants who are in high-risk categories or who have special health concerns have the option to appear remotely rather than in person?
Our administrative order certainly provides that if lawyers or parties are high risk or have health concerns, let that be known to the presiding judge. I think it does need to be specific. So generalized concerns are not what we are interested in, but if it impacts a party or a lawyer, we certainly made accommodation for those and identified another way to accomplish whatever task.
We have another question from our audience about jury selection in trials once they get started again. And can you talk to us a little bit more about what you expect for jury selection? And then a follow-up to that, if a juror tells the clerk that they are unavailable, will the court just keep going until it gets the same number in the jury pool as normal, or handle it some other way?
Well, obviously, we always inquire about availability during the voir dire process to make sure we've got people who can spend 3 or 4 days to hear the case. That won't change. Jury selection may take a little bit longer now. Typically in the civil cases, I'll have a jury by lunchtime. In the criminal cases, I get a jury right after lunch, sometimes as late as 2 o'clock, certainly enough time to do opening statements first day. It's going to take a little bit more time, because I do envision once you bring the pool in, you probably can't do the orientation as a group anymore. We're going to have to limit that to a group of 10. So in a typical civil case, we'll bring in 21 to 25, criminal case 35 or more to get to jury. So orientation is going to take a little bit longer, which may delay the 9 o'clock start time. We already asked the pool to come, the jury pool, to be at the courthouse by 7:30. Not sure, and they have to, and some people have to drive a long ways from some of the outside counties to get here, sometimes as long as an hour and a half. So I'm not sure I'm ready to say come at 7, but to get them checked in, to give them the jury orientation that every juror receives is going to take a little bit more time and probably delay the start of the voir dire process a little bit more. Not sure yet how that might impact voir dire. We may not be able to have, depending on what kind of case it is, civil or criminal, we may need to bring the potential jurors in groups of 10 or less to do that process. That's why my hope is we can start with a civil jury trial, because the number's so much smaller and we can create our new protocol and get ready for a criminal case down the road. So it's going to impact some things. I've already started reviewing what other districts are doing. we're going to have to find what works best for the Middle District and what our judges are comfortable with doing. But yeah, it's going to definitely make the jury selection process a little bit more time consuming than what lawyers are used to here in the Middle District.
Give everyone one last opportunity to submit your questions before we thank Judge Crenshaw for sharing his time with us today. Judge Crenshaw, we have one more question that came across just a minute ago, again about jury trials. Have you considered whether juror notebooks with exhibits will still be permitted once civil jury trials resume?
That's a good question. For me, it will. I probably encourage you all to have an individual notebook for every juror, so there's not, you know, everyone doesn't have to touch what someone else has touched. You know, we may put some limitations when lawyers want to pass the exhibit, let each juror touch it, look at it. Probably wouldn't do that going forward for safety reasons. But a notebook, as for me, speaking only for me, the other district judges may have a different approach. I would encourage you to have a notebook for every juror and with a table of contents. So, and obviously exhibit needs to be numbered. So when exhibit number 20 comes into evidence, you can say to the jury, you can turn to tab 20 and now look at that exhibit. So that wouldn't change because I currently do that before the pandemic. Now other judges may have a different view, but the only real change I can think of offhand would be probably won't pass exhibit, you know, to each juror to touch and look at on their own. And but other than that, I don't think it would change how we deal with it.
We have a couple more questions from the audience. Firstly, what is the anticipated duration of the changes protocol? Do you believe these are all going to be temporary changes only, or will any of them become more permanent?
Are you referring to video and telephone conferences?
I think so, yeah.
Okay. You know, right now that comes to an end at the end of June, I believe. I think it's June the 23rd. Congress allowed us to put in place video and telephone conference call for 90 days. And I think the first 90-day period ends then. I can extend it. The Chief Judge has that discretion, but it requires that the national emergency still be in place. And I have to do an independent assessment that it's appropriate in your district. If for whatever reason the national emergency is rescinded, and otherwise if it expires, then I think the statute says that we have to conclude all video and telephone conference calls in criminal cases no less than 30 days after the expiration of the national emergency. That would not impact us in civil cases. So that's the protocol that Congress established to allow us to do video and telephone conference calls in civil case and in criminal cases for a number of proceedings that before the CARES Act we did not have the authority, for example, to sentence someone by video. So that's of limited duration depending on the national emergency or the particular needs of our district.
And what about other courtroom procedures that have changed because of the pandemic? Are any of those anticipated to last indefinitely into the future, or do you have?
Well, of course, since March, we've had very few courtroom proceedings. Yeah, I think going forward, you probably will. I don't know exactly. We've not decided what we'll do in the Middle District. I can tell you in other districts in Tennessee, judges are mapping out their courtrooms. So plaintiff's lawyers shall be in this box, and the client has a box, and you stay within that box when you're in the courtroom so that we can maintain social distancing, where the court officer will be, everything is mapped out so everyone knows where you can walk, where you cannot walk. Some courts are doing that, and that may have some merit to it, but I don't know if we'll go that far. There, again, I think everyone's trying to figure out what the new normal is going to be for jury trials, and that's why my personal preference is we start with a civil jury trial, because the jury is 6 or 7 at most. The pool's going to be probably 20, 25. Civil case, 1 lawyer, 1 party for each side. So that's I can keep it under 10. I can control who's in the courtroom in a civil jury trial. When the jury goes out on break, I've got a big enough room that they can have all kind of distance between each other. We can explore how to limit the jury's movement here on the 8th floor much easier with a group of 6 or 7 than I can with a group of 12 or 15 in a criminal trial. But all those things are yet to be determined. And of course, we'll always leave discretion for the presiding judge to adjust it to whatever he or she is most comfortable with.
I think we have time for one last question, and it will come from our audience. Given the large caseloads being carried by each judge, is there any possibility of the Middle District being provided any additional judgeships?
Permanent judgeships, or you mean visiting judges?
Well, maybe we'll answer both ways. Any permanent ones first?
But we have no plans of bringing in any visiting judges at all. Obviously, other districts are having the same issues that we are, so that would not be a realistic option. In terms of a 5th judgeship here in the Middle District, that's not on the table. Quite frankly, our case filings would not justify the creation of a 5th judgeship. Before the pandemic and the way Nashville was economically booming and the companies, whatnot, that were moving to Nashville, we certainly did see, and then when we look at the type of cases being filed, we were certainly anticipating in not too distant future a justification could be made for a 5th judgeship. But now we've got to wait and see what things look like. Obviously, the economy is going to have some impact on litigants' willingness to engage in litigation, which is time-consuming and can be expensive, to see if our statistics. But a 5th judgeship is not currently something that we could justify, make a request for. So we'll just have to wait and see what the future holds.
Well, Judge Crenshaw, I can't thank you enough for spending your time with us this afternoon and answering the questions of the members of the MBA. And thank you for your leadership in changing court procedures and helping us navigate these troubling times.
Well, thanks for inviting me. And let me just leave on the message, which is, I think, true for all our judges, but especially true for me. If anybody in the Nashville Bar, any frequent flyers over here have suggestions about how we can do things more efficiently or address particular concerns that litigants or their counsel have, just call me and I'll be glad to discuss it, because I'm always exploring how we can do things better, more efficiently, and especially to the extent we can, be responsive to the bar and the clients they represent. So I welcome all good ideas and be glad to talk to you about it.
Thank you so much. And I know that our federal courts committee is very active and our co-chairs are on this call right now. So I'm sure they heard that message. We appreciate you being open to our suggestions as well. And thank you, Ann, for spending your afternoon with us.
All right. Take care.
Take care.